In this video, we will understand section 87 of Indian Penal Code. As you can see on screen, the title of the section reads, Act not intended and not known to be likely to cause death or grievous hurt. Let us first understand the text of section 87. This section is a little tricky. If we read it straight away, it makes it difficult to understand. So read it with me like this. Nothing which is not intended to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt, is an offense by reason of any harm which it may cause or be intended by the doer to cause to any person above 18 years of age who has given consent, whether express or implied, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause to any such person who has consented to take the risk of that harm. Okay, let us now understand the section in a proper manner. Now I have made a chart here, and in the chart I have filled up the main provision of the section, the basic skeleton, and now we will fill flesh and blood in it to make it meaningful, to make it understandable. Now see, what is the basic skeleton? Nothing is an offense, but that doesn't make complete sense. It definitely does make sense, but not complete sense. This is in the nature of an exception, that is saying that nothing is an offense. Now what, in what manner, how, where, to whom, that we will understand. Now see, nothing which is not intended and not known by the doer is an offense. But then not intended what? And not known by the doer what? That we will see. Mark here, the words are and. So these two ingredients need to be fulfilled at the same time. So let us see what goes here and what goes here. So nothing which is not intended to cause death or grievous hurt, and not known by the doer. What? Let us see. To be likely to cause death or grievous hurt. Now mark here the mental elements that are required. The mental elements required are absence of intention, not required, and absence of knowledge. So in absence of the intention and in absence of the knowledge by the doer of doing these things, no intention to cause death or grievous hurt, and at the same time absence of knowledge to be likely to, of the possibility of the death or grievous hurt, it is not an offense. But still there are certain things to be understood here to make complete sense of section 87. Going a step further, what we find is nothing is an offense in absence of these two mental elements by reason of any harm which it may. So if harm is caused to someone, so because of this reason, that act will not be treated as an offense if whatever comes forward is fulfilled. So that takes us one more step further. So by reason of any harm which it may cause, or which it may be intended by the doer to cause, or which it may be known by the doer to be likely to cause. So when it comes to causing harm, the mental elements are intention and knowledge. Intention to cause, or the knowledge of possibility to cause. So these ingredients are not required to exist at the same time here. Therefore, because the word used is or. But still, This sentence has not yet become complete. Let us see what is. So now the entire section is completed. Now you can see by reason of any harm which it may cause or be intended by the doer to cause to any person above the age of 18 years who has given consent. This is the most important ingredient of this section. Whether express or implied, so consent may be either express or implied, to suffer that harm, or which it may be known by the doer to be likely to cause to any such person who has consented to take the risk of that harm. Just to revise, let us read the section completely once again. Nothing which is not intended to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt, is an offense by reason of any harm which it may cause or be intended by the doer to cause to any person above 18 years of age who has given consent, whether express or implied, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause to any such person who has consented to take the risk of that harm. Now you can, for your own benefit, pause the video and take a good look at this dissected and charted section 87 of Indian Penal Code, and then we move further. Now there is an illustration given in section 87 itself. Let us see what that illustration is. A and Z, these two persons, they agree to fence with each other for amusement. You know, fencing, the sport of fencing. So they agreed to play that sport of fencing with each other just for fun, just for amusement. Now see, this agreement to play this kind of sport for amusement contains within it an implied consent of each. And what that consent is for? It is to suffer any harm which, in the course of such fencing, may be caused without foul play. This is important. And suppose if while playing fairly, if A hurts Z, then according to the ingredients and principles contained in this section, A commits no offense. So, dear students, consent plays a very important role in criminal law. Consent has the effect of exonerating a criminal act in the two situations. And firstly, if a harm short of death or grievous hurt is caused, and secondly, harm which is resulting in death may also be caused if it was not intended. The sections 87 to 89 and 92 of Indian Penal Code, these sections lay down a rule for determining as to when the harm caused to consenting individuals should not be punished in the interest of community. So what is the policy behind exemption from criminal responsibility in such cases? The policy is based on the principle that a man is the best judge of his own interest, and that no man will consent to what he considers injurious to his own interest. And if a man will consent to what he considers injurious to his own interest and decides to suffer a harm voluntarily, he cannot complain of that harm when it comes about. Now, all of you must be aware of a well-known maxim, volunti non fit injuria, aren't you? The meaning of that maxim is He who consents cannot complain of it. You see, consent is a good defense to sex offenses in general. But if once it is proved in the case of rape that the age of the girl in question was below 16 years, her consent becomes wholly irrelevant and the accused is liable for the offense as if no consent were obtained. Now, this section, section 87, it states that consent given by a person above 18 years of age for all acts being done against him, except that of causing or intended to be likely to cause his death or grievous hurt, will exonerate the actor from criminal liability if the consenting man suffers any harm. Let me give you an interesting example. Suppose if a grown man of 40 years, if this man sells his teeth to a dentist for say rupees 3000 and he permits the dentist to pull the teeth out, then the dentist is not liable for causing injury to A's person. This is because only after A gave permission for removal of the teeth that the dentist pulled them out. A therefore is restrained from making a complaint for removal of his teeth. In certain situations, uh, immunity granted under Section 87 will not justify causing of death or grievous bodily hurt or any harm which is known by the doer to be likely to cause death or grievous hurt. In such situations, the consent may reduce the gravity of the offense and may mitigate the rigors of punishment. Okay, I'll give you an example. Suppose there is a man who is accused of committing murder of the deceased, and this accused professed himself to be a snake charmer, and he made the deceased believe that the accused had power to protect the deceased from any harm, and therefore he persuaded, this snake charmer persuaded the deceased to allow himself to be bitten by a poisonous snake. Now see, after the snake bit the deceased, accused could not save the deceased from the effect of snake bite. In this case, the accused was prosecuted for committing murder. But the court held that the consent of the deceased did not excuse the accused from criminal liability. And in that case, accused must have pleaded the defense of consent. But the courts held that consent cannot excuse the accused from criminal liability. The maximum that could be done was the consent could mitigate, to reduce the rigor of liability, and instead of holding the accused guilty of murder, he was held guilty of a lesser offense, that is culpable homicide not amounting to murder. You can note down this was a case of Unai Fatima, and it was reported in AIR 1981 Supreme Court 361, which is equivalent to this citation. Now, when it comes to consent, consent can be either express or implied. And suppose if a question arises, if in a given case there was a consent or was not a consent, then it is a question of fact which depends upon the circumstances of each case. I'll explain express consent with the help of a case law. The name of the case is Bishambar versus Rumal. and it is reported in 1951-52 Criminal Law Journal, page 179. In this case, what had happened was a man from a village had behaved in a very indecent manner towards a Harijan girl. So, on a complaint against that man, a panchayat was constituted to deal with this man. And in the course of proceedings before the panchayat, this man had given his consent in writing to abide by the decision of the panchayat. Now, as per the decision of the panchayat, this man was paraded through the village with blackened face and he was given a public beating. This man then lodged a criminal complaint against the members of the panchayat, and in the case that went on, it was held that the accused, that means the members of the panchayat, acted bona fide, in good faith, and with a view to protect the complainant from more serious consequences resulting from his indecent behavior towards the Harijan girl. And all this done, most importantly, was with the consent of the complainant in writing to abide by the decision of the panchayat. So it was held that the action of the accused, that means members of the panchayat, in enforcing the decision of the panchayat is not an offense because the complainant had consented to the same, and also it was done to protect the complainant himself against a group at Harijans which was armed with weapons and who were about to inflict serious bodily injury on the complainant for indecent assault on a girl of their community. So that was the example of express consent. Now, when it comes to implied consent, it has to be inferred from things like the conduct of the man, the nature of the operation, and such circumstances. Now, for example, when a man takes part in a lawful game like say football or hockey or cricket or boxing, then it is obvious that by participation in the game, the man has given his implied consent to the infliction of a certain amount of bodily injury upon him, which is implicit in the game. But there is an exception to this. If the bodily injury is inflicted in violation of the rules of the game, then the man causing injury will be criminally responsible for it, and the consent will be deemed to have been withdrawn ab initio. That means from the very beginning, the consent will be understood to be not there. Let us take a look at some case laws. The first case law that we will be seeing is R versus Wilson. The facts of this case are interesting. What happened in this case was that the accused Wilson, he was asked by his wife to tattoo his initials on her breasts. Wilson refused, but the wife persuaded him to burn his initials with a hot knife at her buttocks. The wife was not only a willing partner, but she was the instigator of the activity also. Her doctor, who had discovered it during a routine examination, reported the matter to police. Wilson was charged with an assault occasioning actual bodily harm. The Court of Appeal dismissed the charge and held that tattooing is a perfectly lawful activity so long as it is carried out with the consent of an adult, even though actual bodily harm is deliberately inflicted. Now, on this basis, the cases can be squared with there is another interesting case of R versus Anthony Brown, decided by House of Lords and reported in 1993, Volume 2, All England Reports, page 75. Now, in that case, a group of homosexual males were discovered participating in sadomasochistic practices. Now, these practices usually involve the recipient of the activity being manacled so as to be powerless, while another member of the group carried out such activities as the nailing of the recipient's scrotum to a board or the burning of his penis with a candle. Now, all the recipients had clearly given their full consent to what was done. The group had a series of code words which could be used by the recipient to stop the procedures at any stage. And it was also clear that younger persons had been introduced to these practices, and members who had missed that evening's events made that video recording not for sale but for viewing. Now, in this matter, the accused were charged and actually convicted by the trial court with a variety of offences under Section 20, Section 47 of the Offences Against Persons Act 1861. When the matter reached the Court of Appeal, the Court of Appeal dismissed their appeals against conviction. Then the matter went to House of Lords. The arguments of the defendants were rejected. The defense argued that because the injuries were just short of being serious, and the prosecution could only succeed if it could establish a lack of consent on the part of victims, and that the law should respect the privacy of people's homes. These arguments of the defense were rejected by House of Lords by a majority of 3 to 2. The House of Lords held that in this matter consent was irrelevant. The majority in the House of Lords took the view that the conduct was presumptively unlawful because it involved violence, cruelty, and abnormal and perverted homosexual activity. The House of Lords declined to create a new exception to cover the intentional infliction of bodily harm in the course of sadomasochistic practices. The majority held that there were several good reasons why the defense should not be extended to cover these activities. The House of Lords outlined three basic reasons to reject the defense plea. Firstly, it was simply good luck that these men had not suffered any really serious infections or injuries. Secondly, there was a risk of spreading such diseases as AIDS. And thirdly, there was a danger that young persons might be drawn into these unnatural practices. And there was therefore no public interest in permitting such practices. Having lost in House of Lords, the defendants sought to persuade the European Court of Human Rights that their prosecutions and convictions were a contravention of Article 8 of European Convention of Human Rights, which covers the right to respect for private life. The court, that means the European Court of Human Rights, held that although their private life had been interfered with, this was in pursuance of a legitimate aim, and that was protection of health and morals of the community at large. and therefore the European Court of Human Rights turned down the arguments of the appellant accused persons. So, dear students, I stop here and I suppose and I hope and expect that you have gained a basic understanding of this section, and I suggest you to further understand the section in detail by reading good textbooks from your college library. Thank you for watching.